So unit 2 is sources of international law. So sources basically means from where we have got the international law, what are the roots and what are the foundation that has helped in the development of international law. So it is a very easy and brief unit, so we will discuss that, and we will also discuss the questions which may come from this unit, and the long question that come from this unit, which is very important, that is the direct question, sources of international law, and you have to prepare an answer in according to that. So let's start with sources of international law. The sources of international law has been laid down under Article 38 of the ICJ. So this is a charter इंटरनेशनल कोर्ट ऑफ जस्टिस का, जिसके अंदर आर्टिकल 38 है जो प्रिसाइजली एक्सप्लेन करता है सोर्सेज ऑफ इंटरनेशनल लॉ, एंड इट हैज आल्सो बाइफर्केटेड द sources in primary and secondary sources. So the significance of Article 38 is that it provides a proper codification of sources, the origin of international law, from where it had been originated, or the foundation of international law, and it has successfully bifurcated also. ज़्यादा important कौन है, जो ज़्यादा प्राइमरी नेचर का है, एंड फिर सेकेंडरी नेचर के सोर्सेज कौन से होते हैं. फिर आईसीजे का रोल क्या होता है सोर्सेज में. आईसीजे यूजेस दीज सोर्सेज while giving decision or while trying some dispute or while resolving some dispute, and these sources also guides the adjudicating matters related to treaties, customs or general principles and in the ICJ. Next is Article 38 also says that judicial decisions by ICJ or any international courts can also become a source. So the judgment becomes very important, and it can be included and it can make impact on global relations. Also the sources helps in understanding significance of the basis for international law. So this is the first part of sources under international law, Article 38 of ICJ. So this one is very important, and Article 38 is given under this charter. इंटरनेशनल कोर्ट ऑफ जस्टिस ये एक बुक जैसा है जिसके अंदर आर्टिकल 38 में यू विल फाइंड सोर्सेज. Now dealing with this in detail, sources of international law. So international law derives its authority from a variety of sources that define legal norms, principal rules governing the conduct of states and other international actors. So it is basically defining the international law, and it is stating that the sources are the origins from where we have got the definition or meaning of different principles, legal norms and rules that are responsible for governing states and international actors. Here international actors means MNCs, then international organizations, individuals. So these are the reasons we have sources. So under Article 38(1) of the Statute of the ICJ that we have discussed earlier in the slide, we have two main categories of sources, that is primary source and secondary source. So under primary source we have treaties, customs, principles of laws, and under secondary we have judicial decisions, academic teachings, writings or commentaries. So this is the Article 38 that is given under ICJ. So the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply international conventions, international customs, general principles of laws, subject to provision in Article 39, that is judicial decisions. So this is the brief or gist of sources of international law. Now let's discuss it in further detail. So the primary sources are dealt in more detail. So first we are starting with treaties. So these are international treaties. So what are treaties? Treaties are formal agreements between states or international organizations. So treaties are mostly upon a particular or specific subject matter, and after discussion there is this agreement, and the states or countries or international organizations signs them, and once they sign them it becomes ratified. It means that now the obligations of the treaty will become binding on such states and international organizations. मतलब एक इंटरनेशनल लेवल पर अग्रीमेंट हो रहा है डिफरेंट कंट्रीज या इंटरनेशनल ऑर्गेनाइजेशन के बीच में किसी एक पर्टिकुलर मैटर पर, और जैसे ही वो साइन करते हैं, रैटिफाई करते हैं, अब सारे ऑब्लिगेशन, जितनी चीज़ें ट्रीटी में मेंशन्ड है, वो ऑब्लिगेटरी हो जाती है रैटिफाइड कंट्रीज या फिर ऑर्गेनाइजेशंस पर. सो व्हाट आर द एग्जांपल्स? One example is the United Nations Charter 1945. So whichever country has signed this charter, this treaty is applicable on them and it is obligatory for them to follow the charter. Next is the Geneva Convention. If any country is a member of Geneva Convention who has signed this convention, then who has signed the treaty under this convention, then the obligation this convention is giving shall be applicable on the ratifying state. Next is CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, 1978. So India is a party to the CEDAW Convention. So India takes special recognition and is obligated to not discriminate against women in any form. And significance of treaties is that they become legally binding once the countries ratify them, and also it provides a mechanism for enforcement and dispute resolution कि अगर नहीं comply करते हैं तो क्या होगा, enforce कैसे करना है. So all these are under treaty. So treaty is one of the primary sources of international law. Next comes the customary international law. So what is a custom? Custom is a practice being widely practiced and it is widely accepted also. So customary international law, अगर कोई ऐसा सब्जेक्ट मैटर है जिसके ऊपर मैक्सिमम कंट्रीज बहुत टाइम से एक ही तरह की चीज़ें फॉलो कर रहे हैं, तो वो एक कस्टम बन जाता है एंड दैट ऑल्सो बिकम्स लॉ अंडर इंटरनेशनल लॉ. सो customary international law is also a source of primary international law. So customary international law originates from the general practices of states and is binding on all the states. So it is irrespective of whether the countries have signed or ratified the customary international law, it will still be applied. अगर कोई गैप है जहाँ पे ट्रीटी नहीं है, कोई आंसर नहीं है, तो कस्टम्स को देखकर डिसीजन लिया जाएगा. So it is an essential primary source of international law, especially in the absence of applicable treaties. So what are the example? Like prohibition of torture and genocide. So it is a widely acceptable rule that there should not be torture और genocide नहीं होना चाहिए. Genocide क्या होता है? Ethnic cleansing. किसी particular ethnicity को clean कर देना, kill कर देना, assassinate कर देना, so that another एथनिक ग्रुप कैन लिव ओवर देयर. तो ऐसे एथनिक क्लेंजिंग या जेनोसाइड के अगेंस्ट है कस्टमरी लॉज. नेक्स्ट इज प्रिंसिपल ऑफ नॉन रिफॉलमेंट. नॉन रिफॉलमेंट का मतलब होता है रिफ्यूजीज को ऐसी जगह पे वापस नहीं भेजना जहां उनको लाइफ थ्रेट है. मतलब अगर कहीं किसी कंट्री में वॉर चल रहा है या कॉन्फ्लिक्ट चल रहा है, वहां से कुछ सिटीजन्स भाग कर किसी कंट्री में रिफ्यूज लेते हैं, तो आप उनको उस कंट्री में वापस नहीं भेज सकते. सो दिस इज ऑल्सो वन ऑफ द इंटरनेशनल कस्टमरी लॉज. अब इसका सिग्निफिकेंस क्या है? इसका सिग्निफिकेंस ये है कि किसी भी कंट्री को इसको रैटिफाई या साइन करने की जरूरत नहीं है. इट इज वाइडली एक्सेप्टेड एंड वाइडली प्रैक्टिस, सो इट विल बी फॉलोड. सो दिस वाज द सेकंड सोर्स ऑफ primary sources of international law. Now third one, these are the general principles of laws. So general principle का मेन काम क्या होता है कि अगर ट्रीटी और कस्टमरी लॉ साइलेंट है किसी टॉपिक पे या किसी क्वेश्चन पे, तो वो इसको फिल करता है. तो और जनरल प्रिंसिपल ऑफ लॉज क्या होता है? ये वाइडली एक्सेप्टेड होता है और रिकग्नाइज्ड होता है बाय डिफरेंट सिविलाइज्ड नेशंस. इसके एग्जांपल्स है प्रिंसिपल्स ऑफ इक्विटी, जस्टिस, डॉक्ट्रिन ऑफ गुड फेथ और एस्टॉपल. मतलब ऐसी जगह पे जहाँ पे कोई ऐसा क्वेश्चन है जहाँ ट्रीटीज और कस्टमरी लॉज के पास कोई आंसर नहीं है, देन वी विल फॉलो जनरल प्रिंसिपल ऑफ लॉज कि जस्टिस को हम लोग देखकर करेंगे, इक्विटी होना चाहिए, इक्वालिटी होना चाहिए, गुड फेथ में होना चाहिए. सो वी विल फॉलो दीज थिंग्स. So these are some of the primary sources of international law. I have further elaborated treaties and conventions for better understanding. So this is how a treaty looks. This is just the page where different countries have put their seal and signature and ratified them. But treaties mostly एक proper agreement or document जैसा होता है. So this is the picture of an actual treaty. थोड़ा इमेज क्लियर नहीं है, बट यू कैन टेक रेफरेंस एंड इट विल हेल्प यू इन बेटर अंडरस्टैंडिंग. सो व्हाट आर ट्रीटीज एंड कन्वेंशन? इट इज़ अ लीगली बाइंडिंग इंस्ट्रूमेंट, मतलब डॉक्यूमेंट है. अगर आप साइन कर देते हो, रेटिफाई कर देते हो, सील लगा देते हो, देन ऑल दी terms and conditions mentioned becomes obligatory on those countries or organization. और ये मल्टीलैटरल कॉपरेशंस में होता है, मतलब जितने भी ग्लोबल चैलेंजेस है जैसे ह्यूमन राइट्स प्रोटेक्शन, एनवायरमेंटल कंजर्वेशन, ट्रेड रिलेशंस, ये सब चीज़ पे जब एक ट्रीटी साइन होती है तो इसमें सब सारे कंट्रीज का कॉपरेशन से चाहिए. दैट्स वाई ट्रीटीज एंड कन्वेंशन आर कंसिडर्ड सो इम्पॉर्टेंट. अब ह्यूमन राइट्स इश्यूज है या एनवायरमेंटल इश्यूज हैं, तो ये सारे कोई एक कंट्री सॉल्व नहीं कर सकते हैं. फॉर दैट वी नीड ग्लोबल कॉपरेशन और multilateral cooperation. So in this regard, treaties and conventions comes into the play. So treaty and convention is a primary source of international law. Now comes the customary international law. So under customary international law, there are two elements, that is opinio juris and state practice. So under opinio juris, it means that certain principles or customs are considered legally binding, that these practices are legally binding. So it should be obligatory and it should be followed. So some customary rules are opinio juris and state practice. So there are some custom that some nation or state has been practicing for decades or century, and it has become a uniform practice, a consistent practice, so it has become a law. So these are two elements under customary international law. I have also bifurcated the elements. So under article 38(1)(b), customary international law is given. Under article 38(1)(a), treaties and conventions are mentioned. So 38(a)(b) deals with customary international law and it provides for opinio juris and second is state practice. इसको हम लोग दूसरे टर्म में बोल सकते हैं general state practice, objective element, और as accepted as law, subjective element. So under objective element, consistent and uniformity, जनरलिटी एंड ड्यूरेशन इज इम्पॉर्टेंट, मतलब ये सारी चीज़ों का प्रेजेंट होना ज़रूरी है, फिर वो एक स्टेट प्रैक्टिस बनती है. कंसिस्टेंट होना चाहिए कि बहुत टाइम से फॉलो हो रहा है, जनरल सारे लोग फॉलो कर रहे हैं, इट्स अ जनरल प्रैक्टिस. एंड ड्यूरेशन कब से फॉलो हो रहा है, बहुत टाइम से, वी डोंट नो व्हेन इट स्टार्टेड बट इट इज स्टिल कंटिन्यूइंग. सो इन दिस इफ इट फुलफिल्स दीज 3 पॉइंट्स देन इट बिकम्स अ स्टेट प्रैक्टिस, एक लॉ बन जाता है स्टेट में. और सेकेंड इज योर एज एक्सेप्टेड एज लॉ, सब्जेक्टिव एलिमेंट, उसमें होता है ओपिनियो जूरिस, मतलब ऑब्लाइज टू एक्ट, वो लीगली ऑब्लिगेटेड है ये प्रिंसिपल्स एंड रूल्स, सो वी हैव टू फॉलो इट. So these are two elements under customary international law. So customary international law is a primary source of international law which is given under article 38(1)(b). Now the third primary source of international law is the legal principles or general principles of law. So under this there are certain principles that are being followed under international law and it helps in bridging the gap. तो अगर ऐसा कोई इशू या कुछ केस आता है जिसमें इंटरनेशनल customary laws, treaties, conventions are silent, then the court applies these principles and these are generally acceptable principles. So first is principle of equality, जो प्रोहिबिट करता है इंटरवेंशन इन इंटरनल अफेयर्स ऑफ स्टेट्स, मतलब एक तरह से सॉवरेनिटी को प्रमोट कर रहा है हर इंडिपेंडेंट स्टेट्स का. नेक्स्ट इज प्रिंसिपल ऑफ पैक्टा sunt servanda. ये एक बहुत इंपॉर्टेंट प्रिंसिपल है जो बहुत बार कॉम्पिटिटिव एग्जाम्स में भी आता है एंड अ शॉर्ट नोट मे कम ऑन दिस. सो the principle of pacta sunt servanda requires parties to honor their treaty obligations good faith. तो जितने भी पार्टीज ट्रीटी साइन किए हैं उनको गुड फेथ में, गुड इंटेंशन के साथ उसको परफॉर्म करना चाहिए, अपना ऑब्लिगेशन फुलफिल करना चाहिए. नेक्स्ट इज प्रिंसिपल ऑफ गुड फेथ. So this promotes the trust and credibility essential for international relations. So this principle specifically talks about discharging duties or fulfilling the responsibilities with good intention and good faith. Next is principle of non-intervention. It means that states should be protected from any external interference in their internal matters. Again, it is advocating for the sovereign equality and sovereignty of independent states. Next is principle of state responsibility. So it talks about the responsibility of the states if they have breached international law or if they have violated some of the norms or principles given under international law. Next is principle of erga omnes. So this is a principle which talks about working towards a community, that every state has a obligation towards the international community as a whole. So we should work for the entire community. इसका best example हो सकता है environmental law and human rights. One country alone cannot function in a manner to protect the environment of the entire world. It needs global cooperation. So this principle comes to advocate for the international community's well-being as a whole. So every state is obligated to fulfill certain obligations towards international community as a whole. So these are some of the general principles given under Article 38 of ICJ, which talks about the sources of international law, the primary sources of international law. Starting with the secondary sources. So I have included this particular bifurcation which will help with the sources again. So primary, we know international agreements, treaties or conventions. Second is custom, international customs. Third is general principles of laws, which we have already discussed. Now comes the secondary sources. So under secondary sources, we have judicial decisions or case laws, or writing of jurists, and also there is one another heading, that is others, and under others we have academic writings and commentaries. So let's start with judicial decisions. So decisions by the international courts and tribunals like ICJ, ICC, European Court of Human Rights, ITLAws, these have helped in forming the jurisprudence of international law. But there is also one interesting thing: they do not have a binding force, but they do have helped in interpreting and applying international law to specific situations. Next is the writing of jurists. So when a judge gives a judgment or legal opinion, it helps in forming the international law, norms, treaties, customary practice. And here also the words or the theories or opinions given by several jurists have helped in forming the sources of international law. Next comes the others. Academics writings and commentaries. The writings by the some of the scholars, researchers have helped in contributing to the understanding and interpretation of international law. They provide valuable insights and analysis for legal practitioners and scholars as well. So these were the sources of international law. So primary is international conventions, customary laws, general principles, and secondary is judicial decisions, writing of jurists, and under others heading comes the academic writings and commentaries. So I have included a picture of ICJ. This is the International Court of Justice. This is how a bench is there and the proceeding goes on. So if a case comes to them, they give opinion, advisory opinion or decisions, and those decisions helps in the interpretation and application of international law. And also in terms of application of treaties, in terms of obligatory nature of treaties, ICJ helps in its application and its compliance. Let's dive into some of the international cases to understand the principal foundations of international law that we have today. These are basically the founding stones which has helped the development of international law. So this case particularly deals with the jurisdiction claim or state sovereignty. तो इस केस में क्या हुआ था? ये केस में दो शिप थी, एक था SS Lotus and second was Bojkurt. So SS Lotus is the French ship or Bojkurt is of Turkey's ship. So what happened? They were navigating on the high seas. अब high seas क्या होता है? These are international waters. किसी भी state, किसी भी country का कोई claim नहीं होता है high seas के ऊपर. Matters relating to jurisdiction. So no jurisdiction claim over the high seas. तो ये दोनों ships high seas में navigate कर रहे थे, and because of the negligence of the SS Lotus, वो collide करता है Turkish ship के साथ और Turkish ship sank हो जाती है. It means that the Turkish ship goes down. So the Turkey detains the officers of the France who were available, who were on the SS Lotus, और उनको अपने national courts में trial करते हैं for the criminal negligence charges. तो इसमें फ्रांस अब क्लेम डालता है पीसीआईजे के आगे. पीसीआईजे क्या है? उस टाइम पर आईसीजे एस्टैब्लिश नहीं हुआ था, दैट इज इंटरनेशनल क्रिमिनल कोर्ट. उस टाइम पर 1927 के टाइम पे परमानेंट कोर्ट ऑफ इंटरनेशनल जस्टिस था, दैट इज पीसीआईजे. सो पीसीआईजे के सामने केस आता है फ्रांस का, एंड फ्रांस क्लेम करता है दैट यू कैन नॉट प्रोसिक्यूट माय नेशनल्स बिकॉज हाई सीज क्लियरली सेज दैट देयर इज नो जुरिसडिक्शन क्लेम. तो आप कैसे ट्राई कर सकते हो? सो the Turkey also argues and says that they have not violated any international law, क्योंकि ऐसा कहीं पे भी रूल नहीं है कि अगर कोई क्रिमिनल एक्टिविटी होती है हाई सीज में तो उसमें कोई स्टेट क्लेम नहीं कर सकता है. So this case was being discussed in the Permanent Court of International Justice. So जो PCIJ था वो टर्की के फेवर में डिसीजन देता है और बोलता है yes, Turkey has not violated any international law and they can prosecute the French officers over jurisdiction claim because देर इज नो प्रोहिबिटिव रूल गिवन अंडर इंटरनेशनल लॉ. कि मतलब अगर हाई सी में कुछ भी मैटर होता है किसी स्टेट से इन्वॉल्व करके तो ऐसा कहीं पे नहीं मेंशन है कि वो स्टेट जुरिसडिक्शन क्लेम नहीं ला सकता है. दैट स्टेट कैन ब्रिंग jurisdiction claim and can prosecute the accused. So this is one of the very important cases that has given us the idea of jurisdiction. कि ऐसे जगह पर जहाँ पे कोई jurisdiction का claim नहीं है, अगर वहाँ पे कोई specific laws नहीं mentioned या कोई gap है कि इस केस में क्या होना चाहिए, तो वहाँ पर हम लोग ये केस साइट करके बोल सकते हैं that states can exercise their jurisdiction. So this also talks about state sovereignty. So this case is very important. I hope you have understood this. Another such important case is North Sea continental shelf cases. This was filed in 1969 in ICJ. इस टाइम पर ICJ established हो चुका था. And this case is between Germany, Denmark and Netherlands. ये केस हम लोगों का Law of the Sea units में ज़्यादा अच्छे से explain हुआ है. And there are some of the concepts here which you need to understand first. So that will be dealt in the Law of the Sea unit. So I would suggest that this is a very brief. So I will tell you the judgment and facts and details. Continental shelf क्या होता है, delimitation क्या होता है, that is given under your Law of the Sea unit. So go refer to that PPT and I will tell you what was the judgment and why this judgment is important. तो यहाँ पर इन तीन कंट्रीज के बीच में डिस्प्यूट था, दैट इज जर्मनी, डेनमार्क एंड नेदरलैंड, कि डीलिमिटेशन कैसे बनेगा, बॉर्डर कैसे बनेगा कॉन्टिनेंटल शेल्फ का, क्योंकि इन लोगों का जो बॉर्डर था, जो सी का बॉर्डर था, वो कोलाइड कर रहा था. तो इस जजमेंट में क्या हुआ, आईसीजे बोला इक्वी डिस्टेंस मेथड यूज करेंगे, मतलब सबको प्रॉपर इक्वी डिस्टेंस मिलना चाहिए. जस्ट बिकॉज देयर आर सम रूल्स रिलेटिंग टू 200 nautical miles, 300 nautical miles, ऐसा नहीं होना चाहिए कि किसी को कम मिला. So equidistance method was used and because of this the fair and just result was given by the ICJ. And this case is often cited when there is any issue relating to delimitation. जब border draw करना होता है किसी भी country के ocean में, तब ये केस रेफर किया जाता है because this case gave the idea of equity and international maritime delimitation and influence the negotiation on maritime boundaries. इस केस का facts issues अच्छे से law of the seas में mentioned है. Right of passage over Indian territory, Portugal versus India. This is a case of 1960 which was filed in ICJ. So the background behind this case is, in the year 1785 Portugal purchased the district of Dadra in India. अब वो दादरा किधर आता है, यहाँ पर. So the Portuguese traveled through the ocean and they purchased a district in Dadra. So after the independence there were different movements going on in India. Goa liberation movement चल रहा था, ऐसे बहुत सारे movement चल रहे थे where different group of people wanted complete independence from any colony of foreign rule. So in the year 1954 कुछ लोग थे, a group, faction भी बोलते हैं, they marched into Dadra district and they demanded the Portuguese to leave completely. और पोर्टुगीज दादरा डिस्ट्रिक्ट का ये ऐसा था कि वहाँ पे सिर्फ डिफेंस के नाम पे सिर्फ 3 पुलिस ऑफिसर्स अवेलेबल थे. एंड सिंस इट वाज अ लैंडलॉक कंट्री, मतलब इस सारे चारों तरफ इसके लैंड है, देयर इज नो वाटर. सो दी दादरा वांटेड रीएनफोर्समेंट कि उनको और ऑफिशियल्स चाहिए थे डिफेंस के लिए, सो दे कैन डिफेंड देमसेल्व्स अगेंस्ट दोस फैक्शन, बिकॉज 3 पुलिस वालों से डिफेंस नहीं हो सकता था. So the Dadra said that we are going to call for reinforcement, but India said no, you cannot go into our territory. ये इंडिया की टेरिटरी बीच में आ रही थी जिसको पास करना था पोर्टुगीज को, so that they can get supply of weapons and ammunition from Portuguese. So India said no, you cannot do that. So in the year 1960 the Portugal filed a case in front of ICJ against India, claiming that कि पहले से एक ट्रीटी और एक कस्टम चलता आ रहा है ब्रिटिशर्स के साथ था, जिसमें ब्रिटिशर्स अलाउड देम इनोसेंट पैसेज. यहाँ से जितना भी पैसेज था वो ब्रिटिशर्स अलाउ करते थे, क्या दैट इवन इफ दिस डज नॉट बिलोंग टू यू, यू कैन यूज दिस पैसेज फॉर ट्रैवलिंग, और या कुछ भी सप्लाई करना है तो उसके लिए आप ये वाला एरिया यूज कर सकते हो ओशन और अपने डिस्ट्रिक्ट के बीच में. बट जब ये केस अच्छे से जब डिस्कस हुआ, देन द कोर्ट रियलाइज दैट पोर्टुगीज के पास राइट तो था पैसेज का, बट ओनली फॉर प्राइवेट इंडिविजुअल्स, कोई आर्म्ड फोर्सेस या मिलिट्री पर्सनल के लिए नहीं था, या कोई आर्म एम्यूनेशन का सप्लाई के लिए नहीं था. सो दिस वाज ओनली फॉर राइट ऑफ पैसेज फॉर civilians, not for any military assistance or arms supplies. So this case highlighted the relevance of historical treaties and local customs in determining rights obligations in international law. So this was the case of right of innocent passage or right of passage over Indian territory. And also in the year 1961 Goa was liberated. In the year 1964 there was a treaty signed between the Indian government and the Portuguese government, and the land was given back to India and Dadra became the territory of India. So this is a very significant case in terms of treaties and customs and also in terms of India. Asylum case. So this is also one of the very significant cases. It dealt with regional customs and also embassy and asylum issues. तो इस केस में क्या हुआ था, कोलंबिया एंड पेरू, दीज टू कंट्रीज आर इन साउथ अमेरिका एंड इट वाज दीज टू कंट्रीज वाज इन्वॉल्व्ड. इसमें जो मेन अक्यूज था, जो मेन एलिमेंट था, दैट वाज टोरी. ही वाज अ वेरी नटोरियस पॉलिटिकल फिगर हु वाज स्पीकिंग अगेंस्ट द गवर्नमेंट ऑफ पेरू एंड वेरी actively participating in all the anti-government movements. So Tory soon realized that there is threat to his safety and he might get arrested in Peru. So to ensure his safety, he went to Colombian embassy which was in Peru to take asylum. अब embassy क्या होता है? Embassies are the offices of different states in another state to help and assist their foreign nationals. So Tory took refuge or asylum in the Colombian embassy, and Tory demanded that he want to exit Peru and to go outside Peru for his safety, and the Peru should grant him the safe passage. Colombian embassy also stated the same and asked the Peruvian government to grant the safe passage. Since Tory has taken the asylum under Colombian embassy, so now he will be the responsibility of Colombia. But the Peru said no, we will not grant him safe passage. So the case was filed in the ICJ. अब जब ICJ के पास मैटर जाता है तो कोलंबिया बोलता है कि we have custom of granting asylum and safe passage, but soon the court concludes that Colombia had not proven the existence of binding custom that allowed it to grant asylum without the permission of another country. In this case the Peru is there. तो यहाँ पे जो यूनिलैटरल स्टेटस डिसाइड हुआ था दैट टोरी इज अ रिफ्यूजी एंड ही शुड गेट असाइलम, दैट वाज बीइंग क्वेश्चनड. और इसमें जो जजमेंट आया था कोर्ट का वो था कि यूनिलैटरल नहीं होना चाहिए. अगर यूनिलैटरल है तो एक कस्टम होना चाहिए कि बहुत टाइम से हो रहा है, अगर आप उसको प्रूव कर देते हो देन इट कैन बी अलाउड. एंड इन दिस केस कोलंबिया फेल्ड टू प्रूव इट एंड टोरी डिड नॉट गेट सेफ पैसेज आउटसाइड पेरू. So this case highlighted the necessity of proving the existence and acceptance of customary international law, particularly regional laws. Definition of custom क्या होता है? Constant and uniform usage accepted by law. So this was the asylum case which was between Colombia versus Peru. So apart from primary and secondary sources of international law, we have third category, that is the other sources of international law. So these sources are not explicitly written, but they have influenced in the development of international law. So these are basically some resolutions, declaration or recommendations of international organizations or bodies, advisory opinions of the international courts. So they have also shaped the international law. So first starting with the resolution of General Assembly. So this General Assembly, we know this is UNGA, United Nations General Assembly. So whatever the recommendation or declaration is made by General Assembly on any issue, they influence the international law and helps in the development of international law. Although they are not binding, कोई भी declaration या recommendation आता है तो ज़रूरी नहीं है सबको follow करना ही पड़ेगा, obligation नहीं है, but they become recommendation, so people can follow it, the states can follow it. Next is Universal Declaration of Human Rights 1948. So this is also known as UDHR. So UDHR has significantly influenced the international human laws and practice. Because of UDHR, we have so many human rights in place, and also all the three generations of human rights. Next is the resolutions passed by Security Council. Security Council is also an organ of United Nations. So any resolution which Security Council passes, it becomes very important for maintaining international peace and security. So it has also somehow shaped international law. Next is example, that is resolution 1441. So this resolution was passed in 2002 and it is related to Iraq's disarmament obligations and set the stage for the subsequent action to prevent the conflict. So this resolution said that Iraq should not have any arm related obligation, and they should thrive to prevent the conflict and to maintain peace and security in the country. So one of the very significant concept under international law while deciding a matter is ex aequo et bono. So this is a Latin phrase and the meaning is according to what is right and good, or from equity and conscience. So if both the parties, if two states are in the trial, and if both these disputing parties give consent that we are going to follow this principle, then the matter can be decided based on the equity principles of what is good and what is right. So under this there are characteristics. So these things should be there in order to apply this principle. First is there should be the consent of both the parties, both the states, or if there are more states, all the states should give consent for application of this principle. Next is this principle focuses on fairness, what is fair, what is just. So this is the objective behind this principle. Next is flexibility. This principle allows ICJ with a much more flexible approach to decide the matter rather than sticking to rigid rules and principles. Next is rarity of use. This principle is rarely used in while adjudicating cases, because there are many countries who do not wish to opt for such uh, principle, because it may result in not favoring them or not helping in the compensation or the decision that they want. So this is one of the important principle under sources of international law. Advisory opinion of ICJ has also helped international laws development. So whenever there is a issue, many of the states or international organizations refer such issues to the ICJ for its advisory opinion. Since it is an advisory opinion, so it is not binding, but states or international organization can refer it if they want. So such matters have been discussed at international platforms at ICJ, and the advisory opinion has helped in shaping the international law. So one such case is when the United Nations General Assembly requested the ICJ to provide an advisory opinion on whether the use of nuclear weapon in the war is permissible under the international law. So ICJ suggested that the use of nuclear weapon in war is against the principle of international humanitarian laws. So it will violate the principle of international humanitarian law, so it should not be allowed. So this is the advisory opinion, and since it is an advisory opinion by the ICJ, it is mostly considered while giving any judgment or while any deciding any matters. So this has also helped in the development of international law. So these are some of the important advisory opinion given by the ICJ. So in the first one, it is related to Kosovo. Kosovo was a part of Serbia and Kosovo declared independence unilaterally. So the issue was in the ICJ, the UNJ asked for advisory opinion that whether a state can declare independence unilaterally. So the ICJ said yes, they can declare independence unilaterally and they have not violated international law. So under this we got the independence and declaration of unilateral independence principle. Next comes the legal consequences of the separation of Chagos archipelago from Mauritius in 1965. So what happened? The Mauritius gained independence and the UK separated the Chagos archipelago. So the separation of this archipelago was declared unlawful. The ICJ gave opinion that the UK should end its administration on the island and people should have the right of self-determination, and the colonial practices that they are doing in that archipelago is illegal. So this was the advisory opinion given by the ICJ. So both PCIJ and its successor, that is ICJ, have given advisory opinion on many issues and they have played a very crucial role in developing international law. That's why they are also under the others category for the development of international law, that is the sources of international law. So this was the entire unit, that is sources of international law. So that was all in your unit 2, and a question may come directly, that is what are the sources of international law. So you can start with the introduction part stating about what is the meaning of sources and why it is important, and next you can start with the primary sources, secondary sources, and also other sources under which you will get advisory opinions of ICJ, declarations of international bodies, recommendations, and also try to include the case laws which I have given. Those are very important and very easy to understand. It will help you in getting more marks. So all the best for unit 2.